consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Hello and welcome everyone to Immigration and Jobs Talk Show. I am your host Nipasa Pradhan and I'm going to be with you for a while today on this very amazing AMA session that is going to be. But before we start off, I really wanted to give out this very important information and that is displayed on the screen. So by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So welcome once again, everyone, wherever you have joined us from, we are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. So a very warm welcome. And let's make this a very, very interesting and a very participative session as well, because this is an Ask Me Anything session. And it's going to be with none other than our guest who makes sure to visit us every week. And that is none other than attorney Prashanthi Reddy. Thank you so much for doing this. Welcome back to our show. How are you doing today?
I'm good, Nipasa. How are you? It's always wonderful to be on the show.
Thank you so much for joining us. I'm doing good too, and I'm looking forward for this webinar today we're going to have. And thank you all you folks for joining us. So, yes, Prashanthi has, been she is an immigration attorney expert, and she has been practicing for over almost 3 decades now. So, Prashanthi, would you like to tell us where can people find you if they really want to come and maybe visit you at your office as well?
So I'm located in Midtown Manhattan on 38th and between 8th and 9th. So 330 West 38th Street, that's my address. But the best way to reach me is by email. You can send me an email, prashanthi@reddysq.com, or you can visit our website, reddysq.com, and you can contact us that way through the contact us page, or you can call our number 212-354-1010. So yeah, happy to again, Nipasa, as I said, be on the show. Looking forward to some interesting questions and having an interesting discussion on the topic or anything else related to H1Bs, or for that matter, since it's an Ask Me Anything, anything related to immigration law really. We won't
Awesome.
discriminate. We won't discriminate.
But I really have to tell you folks about the topic for today. It's supposed to be H1B visa holders tied to their sponsoring employer or free to switch jobs. So if you can stick to this topic would be great. But otherwise, of course, anything about immigration, just like Prashanthi has already said. So yes, let's hope, and I hope that folks out there have some questions for us very soon. So today, what can they expect? Suppose, what is the scenario right now with the H1B visa holders, who are trying to maybe get a sponsor for themselves, or if they're thinking
So,
about switching jobs, what do they do?
right. So the present scenario is what we're seeing is a lot of people are getting laid off. So they're obviously trying to switch or transfer employers either before they get laid off, in which case they just follow a simple a transfer process, which is more straightforward. So you have to file an I-129 application to transfer your H1 to another employer. The new employer should file the petition at least before the previous job, before they're laid off or they leave the previous job. So what I'm saying is that they have to be presently in status in order to file a H1B transfer application. So you have to file an I-129 petition, pay the required fee, um, and the wherever you're transferring to, that employer, they should be qualified, and the job should qualify for a H1 as well. Of course, that's the basic requirement, and you have to send out all the correct fees. The fees may be different for a transfer when compared to a new H1B petition. So it's the fee is a little confusing right now. So you have to pay attention to what the fee is, because it also depends on the number of employees. So don't that the company has. So don't just presume that since you paid one fee previously, it'll be the same fee. This is with reference to those who are filing their transfer while their H1B petition or their H1B status is still active. But for those who are not able to do so, say you got laid off and your employer didn't give you any notice, or gave you um, some notice, but you're not able to find a job within that period of time, there is a new regulation um, whereby you can transfer your H1 within 60 days of being laid off, or you may choose to leave the job as well. It's not just laid off. The 60 days of termination of your job, for whatever reason the termination is. Um, from the last day that you worked, you have 60 days grace to file the H1B transfer. That's a different kind of transfer. In the previous in the regular kind of transfer petition, you have to show that you're in status, so you'll have to show your H1B approval date is still current. You'd have to show pay stubs from your previous employer or current employer, and you have to show that you're meeting all the terms and conditions of the present H1 that you're with. So sometimes the USCIS will send an RFE asking if you are maintained status. So it's not just pay stubs. They also want to see if you're doing the same job that the LCA was approved for, if the prevailing wage is being paid as per the LCA offered wage and prevailing wage. So they're going to look at pay stubs. They're going to maybe look at your tax returns, W-2s. And they also want to make sure that you're working at the same work location for which your LCA was approved. So they're going to look at documentation related to that as well. So maintenance of status is one of the most common RFEs that we get when we file a transfer of H1. So this is something to keep in mind. Now, if you're doing the 60 days grace period transfer, then they will not ask you for pay stubs as long as it's within the 60 days of termination. But all the other questions they could ask previous to the 60 days, were you maintaining your status? Were you working as per the work location, etc., etc. So that's what the topic was for today, and that was some information that I'm sharing with reference to how to file a transfer and what to keep in mind.
Thank you so much, Prashanthi. And that was quite an insight. And folks out there, I know I can already see you dropping your questions. So I'm very happy that we can jump right in today because it is an AMA session. So, Prashanthi, let's take up the first one already without further ado. This is on YouTube from Daniel. And which visa type provides the most straightforward pathway to permanent residency or green card for employees?
It depends on which country they belong to. So there's no one answer to this. If they belong to Australia, or if they belong to Canada or Mexico, maybe you want to look into the TN or the E3 visa, because that's the most convenient. It's better than H1. If for all other countries, the H1 might be the best option to segue to a green card. If the priority dates are current, and if you don't belong to India and China, for which priority dates are never current, but for other countries, it might be the green card itself that you can file directly to file, to get a green card, instead of going through another route. If the dates are current, or if they're close to being current, you can directly file a green card for your employees. The L1 is also, again, you have to qualify for it. Not everyone qualifies for an L1A or an L1B, but an L1A is a very good option um, as a segue into the green card, because if it's an L1A, it puts you into an EB1 category, which is the best category for employment-based green card. So that's definitely also recommended, provided you qualify to qualify for an L1. You have to be working as a multinational executive or a manager level position for at least 1 year in the related company, in a related company, and then the U.S. company petitions for you. So that's the L1, and it depends really on what you qualify for. So it's best to have an immigration attorney maybe look at your options and let you know as to which is the best visa for you. Most often than not, most people will file for a H1 because that's the most common work visa, which a lot of people qualify for.
Right. Right. But it's always best to consult an expert friend so that, you are on the right path and you're at least sure that you are in one. All right. So, Danielle, I hope if your question is pretty much clear with the answer Prashanti gave. But if you have more questions, we are here for some time. You can keep dropping your questions in the comments. So, the next one now, Prashanti, is from Ansa. And she's asking, do you do consultations for H1B clients who need to have their H4 for their family? And if yes, what's the cost? Okay.
So yes, we do consultations, and please reach out to me via my email to find out what the fee is. I'd rather do that over an email or over a phone call with you.
Awesome. So, Ansa, I think I can just read out or you can note it down. It is scrolling on the screen, Prashanti's details. The telephone number is 212-354-1010. You can email her at prashanti@reddyesq.com and definitely go visit her website, reddyesq.com, and connect with her, Ansa. Thank you for your question. Another this one, Prashanti, the next one is from your channel actually. So this is from Apurv asking, I've heard that after layoffs, a company is unable to file perms for the same position for some time, say 6 months. So have you noticed a decline in the number of perms filed for EB2 and EB3 applications?
Yes, I must say a lot of employees are not filing, haven't been filing perms recently. But remember that once you start the process, the perm actually might take 6, 7, 8 months from the date that you file the prevailing wage. Prevailing wage itself is taking 5 months. And then, by the time you place the advertisements, etc., and you're ready to file, that might take about 9 months. So we're not, with immigration law and with the perms, we're not looking at the present time. We're always looking at some time in the future because that's when we're actually filing. So even if you've laid off some employees, if it would most probably be more than 6 months before you are able to file the new perm cases, even if you start today as of the date of laying off. So you should be okay. Also, you have to remember that the layoff has to be in the same job. If it's a different job, then that those layoffs don't affect your perm application. So these two things are important to keep in mind.
Okay, thank you. Thank you so much. And well, we are also streaming on Prashanti's YouTube channel, and that is Law Offices of Prashanti Reddy. So you can even check her out there. And thank you so much, Apur, for joining us there. All right. So the next question now is from R Singh on YouTube asking, need advice. I-140 approved with Company A in 2021, joined Company B in 2022 with H1B validity till May 2025. Company B has filed perm, which is in process. If I leave Company B, can I still use I-140 approved from Company A for H1 visa extension? Please advise.
So the I-140 approval can be used for. So I-140 is approved with Company A and in 2021, joined Company B in 2022, H1B validity till 2025. Company B has filed perm, which is in process, and then they want to know if he wants to know if he leaves Company B, can he still use the I-140 approved from Company A for the extension? So for those of you who don't know some background, if you file for a H1 and if it is beyond 6 years, meaning you get a H1 for 6 years, that's a maximum period. But there is an exception to that. If you have an I-140 approved, then you can file a H1 beyond the 6 years period. USCIS has um, introduced this regulation because they know that the green cards are taking years and years. So it often happens that people are on H1 for many years before they can actually get a green card, even though they have filed for the green card. So keeping that in mind, yes, you can, because it's been more than 6 months since your H1B was approved. So the for the I-140 purposes, there are two things that you have to keep in mind. One is transfer of the priority date from the previous I-140, and the other is using the previous I-140 to file a H1B extension beyond 6 years. In both instances, for you, it can be done. You can transfer priority date and you can file the extension. But for people who have gotten their I-140 approved and it's been less than 6 months since they got the I-140 approved, then those people can port the priority date for that purpose, but they cannot file a H1B extension if their H1 is more than 6 years. If they've been on a H1 for more than 6 years, so beyond the 6 years, they cannot file it, the H1B extension. They have to wait for the I-140 is approved for more than 6 months before they leave that company, because if the I-140 is revoked, the priority date can be transferred, but they will not be able to file for a H1 beyond the 6 years. So something to keep in mind when you join an employer and you file an I-140 for at least purposes of extension until you file the other I-140, might make sense to stay with the employer for 6 months before you move. Very important, what I've just said. And I suggest, if you are not clear, then you listen to the recording again. But there are two different variations to the I-140. One is for the priority date, and one is for the H1 extension. And the rules are different for both. So with reference to this, Mr. Singh, I guess it's Mr. Singh, we don't know our Singh. For Singh, the answer is yes, you can file the extension and you can also port the priority date, since it's been more than 6 months. He got the I-140
Okay.
approved in 2021.
Mhm. Okay, great. So all the best, R Singh. I hope that you figure out what would be best for you. And you can always contact Prashanthi directly. Her details are scrolling on the screen. So, all right. So, Prashanthi, we have more questions, so we'll take them. Let's take this one from Hema. Hema is asking, how does the H1B exempt visa category accommodate employers seeking to hire foreign nationals for roles that may not traditionally qualify under the standard H1B visa requirements with an emphasis on expedited processing?
Uh, what is the question again? How does the H1B exempt category accommodate employers seeking to hire foreign nationals for roles that may not traditionally qualify under the standard H1B visa requirements? The question is not clear, Hima. I think you should just give your fact scenario directly rather than asking an indirect question, because that way we can answer it much better. Now I just have to guess as to what you're asking. If you don't qualify for a H1, then whether it's your H1B cap exempt petition or not, it's the same rules that you have to follow. It has to be a specialty occupation. There has to be a job available. So all the other requirements don't change. It's just that if you have a cap exempt organization, then you can file without registering under the cap. That's the only difference between a cap exempt organization and filing a cap petition. There are no other differences with reference to eligibility for a H1. With an emphasis on expedited processing, in order to file for an expedited processing, there is premium processing available, and you can certainly use that.
Okay. Thank you so much. But Hima, if you can actually make your question more clear, maybe tell us about your situation and Maybe we can then answer better, as to what you should do. Or you can even contact Prashanthi Reddy directly. Her details are scrolling on the screen. All right, so the next question I have for you, Prashanthi, is from Pedoju asking, Hi, my H1B has not selected in the first lottery. What are the chances of for second lottery for the year 2025 cap? Prashanthi.
We don't know as of yet. We're still have only started filing cap petitions because a lot of employers wait until last moment to file. So we have to wait until June 30th and see. And USCIS is going to see how many petitions were filed. If all the numbers were not used up, the 85,000, then they will run another lottery. A lot of employers have not filed because they say the market is not good, and they don't want to file for a future requirement. So I see that a lot of people are not filing. So it really depends on um,
The
it really
numbers.
depends on the numbers that are going to be filed. It's too soon to say. Some people are of the opinion that there might be a second lottery. It's hard for me to say
Mhm.
right now.
Yeah.
I do see that a lot of people are not filing, but it really depends on how many of them don't file because they have already included, USCIS has um, taken that into consideration by accepting more registrations than their numbers. So they have about 108,000 registrations have been picked, even though they're only 85,000. So they're accounting for those additional numbers. So if after accounting for it, even if there's still a gap between the number filed and the number that are available, then they will definitely have a second lottery.
Okay, and you know what? Best thing, Perujo, is we had a whole webinar discussing this very topic last week. So you might as well go check out that episode. You might get some of your answers cleared there. So, yes, let's keep guessing if we are going to have the second lottery, but let's keep hoping for the best as well. All right, so now next one. This one is also on YouTube. This is from Vasista asking, can I ask my employer to raise I-140 immediately after entering US, or do I need to wait for any specific time?
Um, so you have to usually file a perm first before you file an I-140. But there is no, unless you belong to an L1 category, then you could file the I-140 a year after you enter on an L1.
Mhm.
That's generally the rule. Um, but there is no time requirement otherwise to file for a green card. You can file as soon as you get onto the payroll of the company. You can also file as a future employee as long as your company has sufficient income to show that they have the ability to pay the prevailing wage. So, yes, there's no minimum or maximum time that you have to wait before you start your green card process.
Okay, that's good news for Vasista, I hope. All right, Vasista, thank you for your question. There is a continuation I can see, sorry. So Vasista is asking, totally how much time I'll need to wait for I-140 approval and how much time for H4EAD approval further?
Well, it depends on what basis you're filing the green card for. If it's a regular green card that the spouse is filing, the principal applicant is filing, then the prevailing wage takes about 5 months. The labor cert takes about 8 months to 10 months. If there's an audit, it can take longer, up to a year and a half. And then the I-140 can be premium processed, so that's the shortest period of time. It can get approved within 30 days. So that's the maximum. That's the time that you're looking at. But remember, you also have to take into account between the prevailing wage approval and the filing of the petition, there might be about 3 months that you wait for the advertisements to be placed by the employer, provided this is a regular PALM I-140 kind of filing. So then you might need to add another 3-4 months for the advertisement process.
Okay, thank you so much for taking that up for Vasista, Prashanthi. Let's move on to this next one. This is also on YouTube. This is from Chandan. Chandan is asking, what are the advantages and disadvantages of L1 visas compared to H1B and O1 visas? How does the L1 visa process accommodate the transfer of employees between international offices?
This we'll have to do a separate session on this because it's a lot to cover for one question, but I'll try to be very brief. The advantages of an L1 over a H1 is there's no cap. Um, the advantage of an L1 over a H1 is that the L1A, not an L1B. L1B, there's no advantages except that there's no cap. For an L1A, it falls under EB1 category. For a H1, you may not qualify for an EB1. You might most probably, file it as a EB2 and EB3. The EB1 priority dates are um, much ahead when compared to the EB2 and EB3, so that's definitely an advantage. An O1 is more difficult to get approved, so if you it has to you have to be have an extraordinary ability, and on the basis of which you're filing, you have to be extraordinary in your job, whatever you're filing for. That's the O1, so not many people qualify for that. If you do, then that's great because that leads to an EB1 as well. Um, the L1 is an intra-company transferee, so it is the transfer of employees between related organizations. One organization being abroad and the other one being in the US. So that's what it is. That's the purpose of it. Um, it works very well if you qualify. As I said, there has to be a qualifying relationship between the two
Mhm.
organizations. They have to be either a parent, a subsidiary, or an associate. They have to have an associate relationship with each other. The employee should have worked in that foreign company as a multinational executive. That means in an executive position or a managerial position, at least for a period of 1 year before transferring.
Mhm.
You have to document everything. You have to show that the US company also they'll be working as in a managerial and executive position. You have to show there are enough number of employees in both companies to show that the person is managing two levels of employees at least in an org chart, and to show that they're not taking care of administrative tasks. There's someone else in the organization that takes care of the clerical and administrative work. Otherwise, even if you put down the job description as executive or managerial, USCIS won't believe you because if there are no other employees in the company that are doing executive work, I mean that are doing clerical work or administrative work, they will know that the task falls to you even if you don't put it in the job description. So
Mhm.
all those things are something to keep in mind, and I hope that answers your question.
Yes, yes, I think it is clear. And Chandan, if you have more questions, I hope we can answer. We are still here for quite some time, and of course, Prashanthi, we will cover this a little later as well. Maybe another episode on advantages and disadvantages, and we will definitely discuss this in length. Maybe we will save this for future. All right, so let's move on to the next one. This is from Tulip on YouTube again. I am an H1B holder. Company notified me that they want to apply for PERM and EB2. My fiance is a citizen and we are getting married soon. I'm weighing options here. Oh, there is a continuation. Can you help me with timelines of green card via company versus green card via marriage? Which one is faster?
Via marriage is faster because if you're married to a citizen, correct? She's married to a citizen?
She is engaged. Engaged to um
Citizen, yeah.
my fiance, yeah, citizen.
Right. So if once you get married, this is much faster because it's an immediate relative petition, and you can work within 3 or 4 months of filing the 485 because you can will file for employment authorization document as well. And once you get the EAD, you can work. And once you file the petition, you can remain in the country. And the petition takes about 12 to 18 months. So definitely filing as a US citizen spouse is much faster than filing an employment-based petition because for even for worldwide, the employment-based petitions for EB2 and EB3 are often backlogged.
Hmm. Pretty much every employment-based visa is backlogged, especially for Indian citizens, right?
Correct. But we're
And
not presuming this person is an Indian citizen, even if they're not.
Indian, right? even if they're
Even
not.
for other countries, it's usually backlogged by a certain extent. So definitely, since this one is always current because um, there's no cap for immediate
Mhm.
relatives. There's no green card cap, so any number of petitions can be filed. So that's why it's never backlogged. It's always current.
Great. So, Tulip, I think you should go for the green card via marriage one. All right. So, thank you so much. And friends out there, we will take up all of your questions. Hi to everyone. I'll just say quickly to Srujana and the Patel, then Tavleen, Ranjit. We will take up your questions. Please stay with us. We'll quickly go for a short break. But before the break, I would like to say you can even contact Attorney Prashanthi Reddy directly. And, she's at Law Offices of Prashanthi Reddy. And you can call her in the number 212-354-1010 or email her at prashanthi at reddyesq.com. Visit her website at reddyesq.com. And this is Nipasa Pradhan with Attorney Prashanthi Reddy on Immigration and Jobs Talk Show. We're discussing about this topic: H1B visa holders tied to their sponsoring employer or free to switch jobs. Stay with us. We'll discuss further after the break. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higherightpeople.com or visit our website www.higherightpeople.com. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan with our guest, Attorney Prashanthi Reddy. And friends, today we are discussing about H1B visa holders tied to their sponsoring employer or free to switch jobs. So it is an Ask Me Anything session. You can ask anything under the topic, or as Prashanthi has told earlier, you can ask anything about immigration. So thank you so much for all your questions. So far, so good. I hope that you are getting your answers. And if you have more questions, we are here. So keep dropping them in the comments wherever you're watching us, wherever you have joined us from. We are streaming live right now on YouTube, Facebook, LinkedIn, and Twitter. And even if you're watching this after the streaming has been over, we have our experts. So keep commenting. We will be very happy to reach out to our experts to get your answers for you. All right, so let's move ahead, Prashanthi, and uh, let's take up Shrujana's question now. Shrujana is asking, what are the requirements for the employee to qualify for an O1 visa as an individual with extraordinary ability? And how do we demonstrate the employee's extraordinary ordinary ability through evidence and documentation? What is the process for filing an O1 petition and what is the typical processing time?
So yeah, I was just saying that this is an answer that will take time because it's a lot of information to cover, but I will just give a brief outline because that's all
Mhm.
we have time for today. With reference to O1, you have to show extraordinary ability in your field. It could be in the arts and sciences, it could be in business, whatever it might be in math, it's in the STEM subjects. So you have to show through different there are different subcategories, and you have to qualify under at least three. Some of the subcategories under which what they look at is your number of publications, the number of times that your original publication has been cited, uh, if you have written on your topic, and if you have received any awards, international or local awards. The bigger the award, the more chances of getting an O1. If you have, if you're a member of any of an organization where it's difficult to get membership because only the top of your field are allowed to become members. If you have judged other people's work, whatever that it might be, and the qualifying criteria for the judge is like you have to mention what is the criteria to qualify as a judge. Not everybody can. You have to get letters from your peers showing that you're top of your whatever your field is. If it is in the arts, then you have to show, I mean, newspaper write-ups, that you've been written about in the media, that you're famous.
Mhm.
So these are few of the qualifying criteria for an O1, and the way we prepare a memo with supporting documents under each category to show that the person qualifies for an O1. This again leads to an EB1, so it's very similar to qualifying a person for EB1.
Okay,
And
okay,
what is the
Prashanti. And
processing time? There is premium processing, I believe, for O1. Uh, And yeah, evidence and documentation is what I just mentioned. Every point you have to submit documentary evidence. If you're saying that you're a member of a certain organization, you have to show proof that you're a member. You have to show what is the qualifying criteria to be a member. If you're saying that you've published, then you have to show proof of publications, the citations, the abstracts. Everything has to be, you have to print out everything and submit it. Letters from peers have to be, you need the letters, you need also the resumes from the person writing the letter to show how he qualifies to give you a letter. You have to show that he's top in his field as well. So these are some of the documentary evidence that are usually submitted. Awards, then copies of the actual
mhm.
award certificates. And as to who has received the awards in the past, what is the criteria to get an award in that particular field? So everything you have to establish what is the qualifying criteria, so that the USCIS officer understands how difficult it is to become a member or to get an award, etc., etc.
Okay, thank you so much for taking that up first, Shrujana. And Prashanti, let's take up now this one from Praveen. Praveen is asking, I-129 denied for degree in electronics, doesn't meet job for programmer. 29 OB motion filed as USCIS, error with reply saying 14 years with um, EXP expiry. What should, I
Experience,
don't know,
experience.
experience. 14 years experience, same employer. Okay, sorry. So what are the chances to reopen my case? And it's
So,
continuing saying, I-129 was the sixth extension that was denied after an RFE.
okay, can you go to the previous screen? So the I-129, his I-129 petition was denied, and surprisingly so. If it was approved so many times in the past, I'm not sure why they
Mhm,
denied it this time. That's very unusual. It could be that there was some mistake on the part of the person filing the petition, or USCIS made a mistake because USCIS. I
mhm,
won't put it past USCIS to make mistakes. They always do. But if you have an electronics engineering degree, and um, if first of all, I don't know. Uh, he's saying that the motion to reopen was filed, or a motion or an appeal was filed as USCI's error with reply saying 14 years of experience, same employer, what are the chances? So I can't address this correctly unless we speak some more on a one-to-one basis.
mhm,
But looks like if USCIS denied it based on the fact that you don't qualify because you don't have a degree in electronics, then it could be that if you refile it or you submit on an appeal the experience letters and the evaluation, work experience evaluation from an expert, from a professor in that field in computer science, then, and if you have experience in the IT field for the last 14 years, then you should be able to get an approval on appeal. But if you are filing as a programmer and the RFE was, and the denial is for the fact that maybe they're saying that the programmer position doesn't qualify for a specialty occupation, then that's a different story. Then there's it's much more difficult to get an approval on that basis. But if it's only based on the fact that your experience was not properly evaluated, then
Mhm.
you should be able to refile with a proper evaluation. But again, it depends on um, whether your I-94 is valid still or it has already expired. So those are things that I think strategically you need to talk to. I mean, if you file an appeal, you can still stay in the country and you don't have
Mhm.
to leave in even if your I-94 is expired. So maybe filing an appeal is the best course for you.
Okay, okay. All the best, Praveen. And I think you can directly even contact Prashanthi, maybe tell her about the whole situation clearly and in more details. Maybe you can email her at prashanthi@reddyesq.com, or you can even connect with her over her telephone. You can call her in the number 212-354-1010. And there is a power cut here. Sorry about the beeps, but yeah. Anyway, all right, Praveen, I hope that you have your answer. And if you have more questions, we are here. And let's move on to the next one now. This is from Sachin. Sachin is asking, H1B petition got approved last year, but didn't get US opportunity with my current employer. This is first lottery and petition, and I haven't traveled to the US before. Suggest for any other opportunity.
I mean, you can definitely file a H-1B cap exempt petition through another employer.
Mhm.
If you find another job, you will not be subject to the cap since you've already been counted towards a cap once. So best
Mhm.
option would be then to file through another employer.
Okay. All the best, Sachin. Now let's take up this one from Nirlep. Nirlep is asking, what are the options for H1B visa holders who want to start their own business or work as independent contractors? And how can we explore alternatives such as obtaining an E2 visa or green card? They're considering the challenges of demonstrating entrepreneurial intent and meeting the requirements for business ownership and investment.
So for
What
H-1B
are the
for H-1B options for the H-1B visa holders who want to start their own business, it's a little difficult as of now, or to work as an independent contractor or to file for your own H1. Um, so you can invest in a company passively. You can be a passive investor in a company as long as you're not taking care of the day-to-day activities of the company. But if you want to start your own business and work for that company, then as of now, the H-1B regulations don't allow it because um, H-1B is available for two reasons. One is with reference to the employer-employee
Mhm.
relationship, and the second is that if you're managing a company, it's an administrative position, and usually those positions don't qualify for a H-1. But there is a proposed regulation, and in the proposed regulation, this is one of the change that has been proposed, whereby a person on a H1 can petition for themselves, as long as and they'll get the H1 for 18 months, I believe, to start off with, as long as they are working at least 60% of the time on their technical job, even if they spend 40% doing their administrative tasks and taking care of the company, the H1B can still be approved. But as of now, that has not become a law, and we don't know when it will be or if there'll be some changes to it before it becomes a law. But you can definitely, as of now, you can be a passive investor, but you can't take care of the day-to-day running of the business.
Okay. Okay, Nirlep, if you want more information, keep commenting your questions. We will take them up, all right? And let's go to this next one. This is on LinkedIn. This is from Jitendra Jain. Is it legal to make a bond by sponsoring employer on H1B?
You can put whatever bonds you want, but essentially, the court will decide whether whatever. I mean, you're asking for money ahead of time. Is that what it is? When you're saying bond,
Bond.
you're asking for a certain amount of money ahead of time. before you file for the H1 or before you hire the person. Um, it really depends on what the bond is for. If you're charging a security deposit from your employee for the filing fees, then that's not allowed.
Hmm.
Uh, what is
Okay.
allowed is suing the employer if they leave you, if there is some you expenses that you've incurred, and this cannot be the USCIS fee, but other than the USCIS fee, you can sue them for training expenses, loss of business, etc., for a certain amount of money based on how much the loss was, and then the court will decide whether what they should grant and whether they should grant it or not. That's the legal process for getting uh, recouping your loss if someone says they'll join you and doesn't, or someone joins you and leaves within a few months.
Mhm. Okay. And suppose, this person is asking for money before, I mean, how to say, before he has served for that money, then what about a deal or, I mean, how does it work? Do you have any process for that?
What do you mean, Nipasa? Asked for money for
Means
what?
like signing an agreement or something. So, I mean, when he was saying making legal to make bond by sponsoring employer, I mean, when if the bond means like asking for money before serving for that money, like it's not salary but asking money before your salary time or something like that.
The money is being asked not by the employee but by the employer. That's what a bond means.
Okay.
So the employee is not asking for money here. The employer
Okay.
is asking for a certain amount of money from the employee, um, as an assurance that the employee will not leave them after they go through the whole H1
Mhm.
process. And it's a filing fee, and there's a lot of money involved in getting
Mhm.
a H1. So sometimes employees will say that they will join, they will sign the contract, and the employer will then sponsor them. They'll get the H1 and the employee won't join. So there's a lot of loss for the employer there, and sometimes the employers will take a bond or take a certain amount of money as a
Mhm.
security, as a surety from that person to make sure that they join. That's what I
But that's
mean
illegal,
by a
right?
bond. Um, yeah, because it depends on what the bond is being asked for. If it's for the
Mhm.
filing fee, then they're not supposed to ask for the bond, and that's what it's for, because there's no other expense except for the filing fee in the beginning of the process.
Mhm. Right. Okay, thank you so much for taking that up, Jitendra. If you have more questions, we are here to take them up. And yeah. So, have you faced any instances like that, by the way, Prashanthi? Any
Yeah, a
cases?
lot of employers ask for a bond, but it usually is outside of the legal. Um, it is an understanding between them and the employee, and it usually doesn't go to court. But I have not, and I don't litigate, so I have not really worked on those cases where such a thing happened and maybe the employee complained to, again, these people are in India half the time, so the bond is taken in India. So really, not much that you
Mm-hmm.
can do with reference to U.S. law. U.S. courts can do with reference to that matter. So no, I haven't seen or dealt with that kind of a case, except for giving advice. I haven't actually been part of a lawsuit or anything like that, or helped file a lawsuit.
Okay,
But
Prashanthi.
given plenty of advice on that matter, and what to do and what not to do and how to go about it.
Great, great. All right, let's move on, Prashanthi. Let's take up this next one. This is from Rakhi asking, when comparing the H1B visa and the L1 visa for employers aiming for rapid recruitment, how do the respective provisions for dependents impact the decision-making process?
Um, when comparing H1 and the L1, uh, how do respective provisions for dependents impact decision? Um, so the L2 dependents can work immediately upon them being in an L2 status. They don't need an EAD application. There is no expiry of EAD, so they're definitely better off work-wise. L2 dependents are better off. L1 dependents who are L2s are better off than H4s who are H1 dependents. A H4 can only work if the primary applicant, the H1 spouse, has an I-140 approved, and then there's an EAD process that you have to go through, the processing time. The EAD will expire, and then you have to refile while the EAD has expired and the petition is pending. You cannot work for the employer. So definitely an L2, you're better off being in an L2 from an employment perspective than being in a H4.
Okay. Okay, thank you so much for taking that up for Rakhi. And Prashanti, we just have some more time. That's why running through the questions so that
Yes, then
we
I'll
don't
try to
miss
answer them
any.
quickly. Yeah, I'll try to answer
Right,
it
right.
quickly.
Cool. So we have Kumar now. Kumar, this is on your channel, by the way, Law Offices of Prashanthi Reddy. Welcome to Prashanti's channel as well. This is from Kumar asking, I am an H1B holder and I would like to invest money on existing company by 50%. Can I apply for EB5?
You can apply for EB5, but please keep in mind, and yes, you can invest in an existing company, and that will qualify for the EB5 as a new investment in an existing company. But you can apply for EB5, but keep in mind, a lot of people don't know this, but processing time for EB5 is 4 years now. So even if you apply, it's not like you're going to get the green card tomorrow. And once you apply, somebody else will have to be taking care of your business or managing your business for the next 4 or 5 years. Because on a H1, you cannot do that. You have to wait to get the temporary green card to manage. So there is a gap between the time you invest and the time that you're actually able to manage your business. Or you just have to invest and put it into escrow and file a petition that you are going to, just saying that you're going to be doing everything and not actually doing it. Then, of course, the chances of approval are lesser when compared to actually putting the investment at risk and running the business. So something to keep in mind. It's not easy because of the logistics of the whole thing and the
Okay.
processing time.
Okay, okay. Thank you so much. That's Kumar. Thank you, Kumar, for your question. Now let's move on to Ansa. Ansa is asking, the company that filed the H1B on my behalf will be changing its name on the 1st of July. So would that be an issue for the filing process?
No, if it's only a change of name, then that should not impact your H1B as long as the federal ID number is the same and the business is the same. They have to submit a name change document showing that the name has been changed successfully, and that's all that's required to file your H1.
Okay. Like an affidavit.
You have to actually apply with the state for a name change, and then they approve the name change. So it's like a certificate that they give.
Okay. And the only problem is, I mean, there will only be problems if the, how to say, the job description is not the same, that there's a change in job, right? That is only going to be a problem. So as long as it's just the name, there's not going to be any problem.
Yeah, I mean, the job is, if this is a first time filing of a H1, the job description also is not an issue. So the only issue
Okay.
would be is if the FEIN number changes, the federal ID number, then the company has
Okay.
changed. So therefore, um,
Hmm.
it's a different company filing.
So it'll be difficult then. All
Yeah,
right.
I'm
Thank you so much.
presuming she's talking about the registration cap process. So maybe one company registered and then they changed their name. So if it's a different company filing, then obviously it's a problem because only the company that registered can file.
Right. Thank you, Prashanthi. All right, let's take up this one. This is from Sanjay. And I think this will be the last question we will take up. So, can an E2 visa be a viable option for a foreign national entrepreneur who wants to start a business in the USA? And how can we demonstrate the required substantial investment and non-immigrant intent to obtain approval? So, considering the business is in the early stages of development and the investor has limited funds, but has a strong business plan and potential for growth?
Again, this is a whole deep dive into the E2 process. This is the treaty trader or treaty investor process. This is available only for people from certain countries. So you have to, if you're an Indian national, it's not available for you. So if you do qualify based on your country, then you have to, it really doesn't matter. It's not the number that matters, it is how much is the required amount for that particular business. For example, a restaurant, a business might need more than what you would need if you set up like a consulting company, an IT company, right? Because there's not much investment involved in an IT company. It's just your office and a few people that you hire. But in a restaurant, there's a lot of investment. You have to buy, you have to lease the premises, you have to redo the premises, you have to buy all your kitchen equipment, you have to buy a lot of furniture, etc., etc. So there's a lot more investment um, in a restaurant when compared to, say, a IT consulting company. So it really, the amount of the amount of investment really is closely related to the type of business that you're in. So if you submit a business
Mhm.
plan then that should be able to, you should be able to show the correlation between the business and the amount that you've invested in a business plan.
Okay. Okay, great. Thank you so much. Prashanti, I think we'll take two more. I mean, we have a few more minutes. So, sorry, the Patel, we are sure going to take your question. We are going to take it right now. So, let's take up. I'm sorry for asking this in H1B specific. Okay. I have applied for a green card in May 2023 on U visa. Normally, how much time it takes to get approved green card on U-based visa? And right now, I'm holding 5 years of WP with parole after finishing 4 years of U visa.
uh WP, I'm trying to remember what WP is. With parole after,
Mm,
so I'm applying for GC. So usually a green card takes about 12 to 18 months to file, depending on if you file the 485 or not. The U visa can take an additional, 10 months or 12 months to get approved. Um, so that's the answer to the first part. And of course,
WP is work
the
permit, he
visa,
says.
work permit. Okay, thank you, thank you. Right now, I'm holding 5 years of work permit with parole after finishing 4 years. Okay, so that's your present status. It'll
Mhm.
take a couple of years for your U based green card to get approved, provided everything goes well.
Okay, okay. All the best, the Patel. I hope everything works for you. And if you have more questions, you can directly contact Prashanthi. The details are scrolling on the screen. And I hope you got your answer, by the way. Let's take up this last one, Prashanthi. This is from Ajay. Ajay is asking, I am on an H1B visa, which expired in March. Can I travel to Canada for a couple of days and return to the USA with an expired visa and a valid I-94 under the automatic revalidation program?
It depends on what the purpose of your travel is. If you're traveling only for pleasure, then yes, you don't need a visa to travel between Canada and the US. You could travel on your I-797 and I-94.
Okay, great. Ajay, thank you so much for your question. I hope you got your answer. And thank you so much, Prashanthi, for being so patient. And I think we covered all the questions today. So I'm very happy about that too. So thank you so much for taking up each one of them on behalf of the viewers and participants as well. Thank you, Prashanthi, for doing this today.
Thank you, Nipasa. Always a pleasure, and we had a lot of interesting questions now. I hope it
Indeed.
helps everyone that we answer these questions. Thank you.
Thank you so much. I hope to see you again next week, and I'm looking forward already.
Same here.
All right, Prashanthi, have a great day ahead. And you too, friends out there, wherever you joined us from, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter, and also on YouTube on Prashanthi's channel, that is Law Offices of Prashanthi Reddy. And friends out there, if you have more questions, you can contact Prashanthi Reddy directly. Her email is prashanthi@reddyesq.com. You can even call her on the number 212-354-1010, and definitely check her out on her website, that is reddyesq.com. Also, friends, if you're looking for project placement, green cards, EADs, anything TN, anything related to immigration, you have questions. If you want to know anything, you can contact me directly. I am Nipasa Pradhan on Immigration and Jobs Talk Show. My phone number is 408-335-6444. You can even email me at nipa@higheritpeople.com and check us out at higheritpeople.com. It'll be a pleasure to get to know you. And thank you, friends, once again, wherever you join us from. Don't go anywhere because we have another webinar coming up on our channel, and that's going to happen in another hour. So if you haven't as yet, hit the notification icon, click the bell icon, subscribe to our channel, and stay updated. We would love to have you on our next session again. And this is Nipasa Pradhan signing off for now from Immigration and Jobs Talk Show. Bye bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.